what do you mean I have to defend myself in court? I don't know what all the laws are and the different statutes and what it is can be and what can be. I'm dealing with the attorney for the prosecutor that knows a lot more than I do. I need some help. Oh, right. Right to have an attorney defend you. That's the Fifth Amendment. Let's talk about that next. Hey, it's Timothy, also at 9533 Training Consulting, and we want to go over the Fifth Amendment. It's our fourth video in our series. We did skip the Second Amendment. We'll definitely come back to that in depth. But we want to go over it so that we can learn some of the protections that are in there for us and what it was written for and what it covers so that you can have the correct information to be armed as an American citizen. The Fifth Amendment establishes a number of legal rights that apply to both civil and criminal proceedings. It contains several clauses. It guarantees the right to a grand jury. It forbids double jeopardy, being tried again for the same thing. Think O.J. Simpson. If the glove does not fit, you must acquit. It protects a person against self-incrimination, being a witness against oneself. This is also called pleading the Fifth, like our sheriff in Santa Clara County in a corruption probe. Pleaded the Fifth. The Fifth Amendment requires due process in any case where a citizen may be deprived of life, liberty, or property. Anytime the government takes private property for public use, the owner must be compensated. So what does the Fifth Amendment say? It says, no person shall be held to answer for a capital or otherwise infamous crime unless in a presentment of indictment by a grand jury, except in cases arising in the land or naval forces or in the militia, when in actual service in time of war or public danger, nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb, nor shall be compelled in any criminal case to be a witness against oneself or be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation. So let's break down and take a look at its individual parts, starting with grand jury. A grand jury is a jury that decides if a trial should be held. They look at all the evidence and then decide if a person should be charged with a crime. They look at all capital and infamous crimes, cases involving treason, certain felonies, or gross moral turpitude. Think Santa Clara County Sheriff. If they decide there is enough evidence, then they will issue an indictment and a regular trial will begin. The grand jury is only used in cases where the punishment of the crime is severe, such as life in prison or the death sentence. Grand juries traces their roots back to the, and I'm going to misspell it or mispronounce it, the Azine of Calderon, an enhancement by Henry II of England in 1166. The United States is one of a very few remaining countries that use grand juries. Double jeopardy. Double jeopardy clause in the Fifth Amendment forbids a defendant from being tried again for the same or similar charges in the same case following a legitimate acquittal or conviction. In common law countries, a defendant may enter a premeditatory plea of artefois acquit or artefois convict. Artefois means in the past in French. It means the defendant has been acquitted or convicted of the same offense and cannot be retried under the principle of double jeopardy. The original intent of the clause was to prevent an individual to go through a number of prosecutions until they get a conviction. Basically, oh, you're innocent? Try you again, try you again. Oh, now you're guilty, we're done. Can't do that. Taking the fifth is what we hear about the most. It's perhaps the most famous part of the Fifth Amendment. It is the right to not testify against yourself in a criminal trial. In a criminal prosecution, a person has the right to refuse to incriminate himself or herself. It's also called taking the fifth, or more commonly, pleading the fifth. The government must present witnesses and evidence to prove the crime. The intent of this clause is to prevent the government from making a person confess under oath. A person may not refuse to answer any relevant questions under oath unless the answer would incriminate him or herself. If the answer to the question to the witness stand could be used to convict that person of a crime, he or she can assert the Fifth Amendment rights.
A new twist in that alleged bribery case involving the Santa Clara County Sheriff's
Maria Medina
Office.
explains a well-known sheriff's captain faces prison time if found guilty.
Released 911 pages of testimony and exhibits presented to the grand jury investigating this case.
This is the undersheriff, Rick Sung. His lawyer confirmed to us that Sung is in fact a target of the new grand jury.
Once again, think about the sheriff of Santa Clara County, currently under criminal indictment for bribery and corruption in concealed carry permits. While under oath with the grand jury, her response to all questions concerning the case were, I plead the fifth. Every question she answered with, I plead the fifth. So if the purpose of pleading the fifth is not to answer any questions that might incriminate yourself, think about that next time you're voting for the sheriff of Lori Smith in Santa Clara County, California. She pled the fifth in a criminal grand jury hearing. Interesting. The authors of the Fifth Amendment intended the provisions to apply only to the federal government. Since 1925, under the Incorporation Doctrine, most provisions of the Bill of Rights are now applied to the state and local governments. Since the landmark decision of Miranda versus Arizona in 1966, when they arrest someone, police are required to include the right to remain silent as part of their legal Miranda warning. The wording may vary, but let's detour, exit stage right, or your right's this way, and talk about the Miranda rights. You've probably heard it on TV, in the movies. You have the right to remain silent. Anything you say can't be used against you in a court of law. Well, when they arrest someone, that's what they need to say. The statement is called the Miranda warning. Police are required to tell people this before they question them as part of the Fifth Amendment. Of course, no one ever decides to shut up. They decide to talk anyways, but they've given you your warning. It reminds citizens that they do not have to testify against themselves. Say you're pulled over for speeding, and you know you were speeding. What's the first thing the officer asks you? Do you know how fast you were going? Well, if you say, yes, officer, I was doing 90 miles an hour. Do you think that they can use that against you? Abso-frickin-lutely. Always be polite. So let's talk about the Miranda warning. The Miranda warning was created 52 years ago. And the phrase Miranda warning was born after the Supreme Court ruled in a landmark case about the Fifth Amendment. The Miranda in the Miranda warning was Ernesto Miranda. He was arrested in March 1963 in Phoenix and confessed while in police custody to kidnapping and raping charges. His lawyers sought to overturn his conviction after they learned during a cross-examination that Miranda wasn't told he had the right to a lawyer and had the right to remain silent. Miranda had signed a confession that acknowledged that he understood his legal rights. I can tell you right now, I don't understand the entire vehicle code. If you've ever seen it, at least in this jacked up state, it's this big. The Supreme Court overturned Miranda's conviction June 13, 1966. In its ruling of Miranda versus Arizona, the establishment guidelines of how detained suspects are informed of their constitutional rights, the decision consolidated 3 other cases that dealt with related issues: in California versus Stewart, Virginia versus New York, And Westover versus the United States, in a 5-4 decision, Chief Justice Earl Warren said, "It is not admissible to do a great right by doing a little wrong. It is not sufficient to do justice by obtaining a proper result by irregular or improper means." The syllabus for the case includes one of the best known sentences in American culture. The person in custody must, prior to interrogation, be clearly informed that he or she has the right to remain silent and that anything he or she says will be used against them in a court of law. He must be clearly informed that he has the right to consult with a lawyer and to have a lawyer with him during interrogation. And if he or she is indignant, meaning they cannot afford, a lawyer will be appointed to represent them. Justice John Marshall Harden II and Byron White issued dissents. In their dissent they said, "Nothing in the letter or the spirit of the Constitution, nor in the precedence squares of the heavy-handed and one-sided actions is so precipitously taken by the court in the name of fulfilling its constitutional responsibilities," said Harlan. The Miranda warning actually includes elements of the Fifth Amendment, protection against self-incrimination, the Sixth Amendment, right to counsel, and the 14th Amendment, application to the ruling in all 50 states. However, there are common misunderstandings about what Miranda rights are and how they can protect someone under criminal investigation. First, there isn't one official Miranda warning that is read to a suspect by a police officer. Each state determines how their law enforcement officers issue the warning. The Supreme Court requires that a person is told about their right to silence, their right to a lawyer, including a public defender, their ability to waive their Miranda rights, and that they tell investigators under questioning after the detention can be used in court. The Miranda warning is only used by law enforcement when a person is in police custody and usually under arrest and about to be questioned. Anything you say to an investigator or police officer before you're taken into custody and read your Miranda rights can be used in court of law, which includes interviews where a person is free to leave the premises and conversations at the scene of an alleged crime. In fact, Ernesto Miranda came into a Phoenix police station voluntarily to answer questions in 1963. He also took place in a police lineup. Now, back to our regularly scheduled information. Due process. Due process. The Due Process Clause guarantees every person a fair, just, and orderly legal proceeding. The Fifth Amendment applies to the federal government. The 14th Amendment to the United States Constitution, among other provisions, forbids states from denying anyone their life, liberty, and their property without due process of law. So the 14th Amendment expands the Due Process Clause of the Fifth Amendment to apply to the states. Due process means that the government must follow the law and not violate any part of it. An example of violating due process is when a judge shows bias against the defendant in a trial. Another example is when, say, the prosecution fails to disclose information to the defendant that would show the defendant is not guilty of a crime. Eminent domain. We've heard about this one before. The last section says that the government cannot take a person's private property without paying them a fair price for it. It's called eminent domain. The government shall not take private property for public use without just compensation. The Fifth Amendment restricts only the federal government. The 14th Amendment extends this clause to include actions taken by states and local governments. Whenever the government wants to buy property for public use, they make an offer to the owner. Now, if the owner does not want to sell the property, the government has to take him to court and exercise a power called eminent domain. The name comes from the Latin term dominium eminentis. I mispronounced it 100%, meaning supreme lordship. The court then condemns the property, meaning it can longer be lived in by people, then allows the government to take over the property, but they must pay just compensation to the owner. In other words, the government body must pay what the property is worth. Some interesting facts about the Fifth Amendment. The Fifth Amendment only applied originally to the federal courts, but it now applies to all states through the 14th Amendment. The concept of due process and the grand jury goes all the way back to the Magna Carta of 1215. Corporations are not considered natural persons. This may not be protected by the Fifth Amendment. The Fifth Amendment to the United States Constitution is part of the Bill of Rights. The amendment establishes a number of legal rights that apply to both civil and criminal proceedings. A case heard before the United States Supreme Court is Kello versus the City of New London in 2005. It was decided in favor of allowing the use of eminent domain to transfer land from one private owner to another private owner. The court upheld the City of New London, Connecticut's proposed use of the petitioner's private property qualified as public use. It fell within the meaning of the takings clause. The city felt the property was in poor condition and the new owner would improve it. This extension of the takings clause has been very controversial. The police can ask you questions about identification, including your name and address, without a Miranda warning. And they can use any spontaneous expressions made by you as evidence. For example, if you say something without the prompting of police before you're taken into custody. Oh my God, I can't believe I killed him. Well, you gave it freely. Of course, you're still protected by your Miranda rights. After you're detained, even if you waive them after an arrest, at any time during the interrogation, you can stop answering questions and ask for a lawyer. Here's an interesting fact about you about Mr. Ernesto Miranda. Although his original conviction was set aside by the United States Supreme Court ruling, he was retried and convicted and was in jail until 1972. Then, in and out of jail several more times until 1976. After being released in 1976, he was fatally stabbed during a bar fight. His suspected killer was read his Miranda rights and didn't answer questions from police. There was never a conviction in Miranda's death. Hopefully that's going to give you some really good insight as to your Fifth Amendment. And you know, finding out what your Miranda rights are for, eminent domain, right to remain silent, double jeopardy, grand juries, things that you hear about always, you hear about these things on the news, but you didn't know where they came from. Hopefully now you do. I hope you're really liking the information we're giving. I'm really trying to put something together. We're putting together the first 10 Bill of Rights. If there's something you're looking for a particular piece of equipment, something you want to have something more deep dive into, put it in the comments below. I'll definitely make sure we look into it and see if we can do some research, put something together for you. Hit that like, hit that subscribe, hit that bell. You don't want to miss what's coming up next. As always, on time, on target, never quit. Hoo-yah.